Well, welcome everybody to the Finnish Roundtable of DB in the Nordics. As some of you may be aware, we started off this series of DB in the Nordics primarily because dispute boards really do focus on dispute avoidance. And in today's times of constrained finances and the complex projects, it is much better to avoid disputes in the first instance before you have to try and resolve them. But dispute boards are a bit new to the Nordic countries. And so we kicked off the series to introduce dispute boards and to discuss what is happening around the Nordic countries that may be similar to dispute boards. So while the term dispute boards might not be used, there may be similar tools that are out there that are being used and that can be tailored and maybe are actually similar enough to dispute boards, and we can start cross-learning and adopting some of those techniques and learn more about dispute boards. But the focus is really project success and how it is that we can avoid disputes in the first instance before we escalate. I am joined today on this Finnish roundtable by three esteemed professionals, and I'm happy to say it's an all-woman panel with movers and shakers in the legal industry in Finland. And I'm going to allow each, or not allow, but invite each of these ladies to introduce themselves because I cannot do justice to their CVs and their backgrounds. So I'm going to do this in alphabetical order, and Annette, the floor is yours.
Okay, thank you. Thank you, Aisha. Good afternoon to everyone. I'm Annette Kavalev. Briefly said, I'm an energy lawyer with a past in in-house legal department and also in the business, which I was in at Fortum as my last assignment. I have been involved with most types of contracts in this area and recently also as a private practitioner with large-scale energy projects. The OL3 nuclear power project, which is currently actually up and running in a test phase, which is good for the energy balance in Finland, not having to import so much from Russia soon. I have also, during my 20 years as private practitioner, mostly worked in an in-house lawyer-like manner, but I have been sitting as arbitrator as well. And in that capacity, I have also seen how arbitration is not always the ideal solution for businesses and become more and more interested in dispute avoidance and dispute board work. I have some experience from a handful of cases, which I will share with you when we go along.
Super.
Thank you.
Thank you so much, Annette. Emma, over to you.
Thank you. So hi, everyone who's tuning in. My name is Emma Niemistö. I'm a partner in a Helsinki-based law firm called Merilampi. I specialize in construction and project law. And I would say that something that describes me pretty well is that I have a half of an engineer brain in me because I've also studied construction economics and management in the Helsinki University of Technology. So that's something that as a background, when I look at the construction sector and also the legal developments, I kind of tend to think of it also from a project management perspective, which has been one of my favorite topics, even from the days of studying. I also act, in addition to counsel work, as arbitrator. I've also acted as mediator and party appointed experts in some disputes, and even had the pleasure to pilot a dispute board in Finland, which I can tell you a little bit more about later on. But that's basically my experience in a nutshell.
Thank you, Emma. And now, Gisela.
Thanks. Good afternoon to everyone. My name is Gisela Knuts, and I'm a partner at Roscher, the Nordic law firm based in Helsinki and Stockholm. I am soon moving on in my career to my next step, which will be as a full-time arbitrator as of 1st of June. My background so far has been both as counsel and of course also as arbitrator in a variety of commercial disputes, some of which also have been project and construction. And of course, in my coming role, I will focus even more on being an arbitrator in that type of projects. In addition to that, maybe sort of my take on this topic is also partly an academic one, because I did my doctoral thesis almost 20 years ago on ADR, and I have therefore approached the theme of ADR and dispute boards very much also from the sort of academic viewpoint. Super happy to be here.
Well, we're super happy to have all of you, because I think this is the fertile ground for a really fulsome discussion and roundtable about disputes and how to prevent them, from both from an in-house counsel, outside counsel, academic, program management, the engineering half. I add a little bit of the engineering to Emma's engineering half a brain there. Well, let's just dive into this, and I'd like to start by setting the stage. About Gisela mentioned ADR, but Emma, can you help us understand the spectrum of ADR tools that's available in Finland? Is it?
Sure, maybe I'll start from the kind of council approach of us having a role and the goal of always kind of trying to prevent and avoid claims at the onset the best way we can at any given situation. And I think project personnel and in-house counsel should share this view, if only just for the cost control perspective. So I would say, if you think about dispute resolution or avoidance, the preventative part starts even from kind of joint planning and good risk management, having basically a fair and balanced allocation of liabilities and risks in the project. I know this sounds naive, but these are all steps to achieve a good contract to start with, which is the basis for any kind of clarity in the liabilities between the parties. And then if you think about the amicable ways of reaching resolution, first of all, obviously it's less discussed, but it's always important for the parties to at least try to solve their disputes by way of negotiation amongst themselves. And I would say that these negotiation tools, you have the unassisted negotiation, and then of course you can also bring elements of basically third-party assistance also to the commercial and legal discussions among the parties. Basically, this could entail dispute review boards. This could entail formal mediation, kind of a more structured mediation, but it also kind of helps in having kind of an early neutral evaluation, or even having counsels kind of help the parties, or outside experts help the parties solve their disputes by way of basically assisted negotiation. And sometimes what you see in the field is that the parties would actually like to have someone, instead of just facilitating, for example, a mediation proceeding, they might actually want the expert or the third party to kind of form an evaluative opinion. And obviously you can ask for a non-binding expert opinion, be it from a technical or a legal expert, but you could also either by way of certain provisions in the dispute resolution clause, or by way of a separate contract in an ad hoc manner, establish that the parties would want a binding decision from the experts at the end of a certain type of structured negotiation proceeding. But basically these are all kind of phases which I deem to precede the actual kind of formal dispute resolution going into arbitration or general court. So I think those are basically the tools that I would emphasize as the parties having more control over.
Thank you, Emma. And Gisela, I cannot resist with your PhD. From an academic perspective, is this generally how you view ADR tools? And we heard a little bit about dispute review boards. And so maybe you can expand on that.
Sure, absolutely. So I think I totally agree with Emma. And I think, of course, the big distinction is between sort of facilitative tools and then tools that in some way have an adjudicative element to them. And a little bit depending on the type of project, of course, each of these play a very important role. The tricky thing, I think, from council's perspective is, or when you negotiate the contract, that you never know in advance, or it's difficult to know in advance which one or which sort of type of tool will fit the best. And that's why sort of we all, of course, see a lot of multi-tiered clauses which give the parties certain freedom in this respect. I think the beauty of the dispute review board is that there sort of you get, especially with standing boards, that you get sort of people on board in a very early stage of the project, and you get support to the project all along the way. And that's, of course, from a sort of academic point of view, exactly the point that you try to avoid getting into a full-scale dispute. So indeed, I agree with Emma's view.
Before I bring Annette into the conversation, I'd like to just looking, you did say you were an engineer, Emma. So I just, and looking at the construction space, do you see, which is obviously prone to a lot of disputes, do you see the utility of having these standing neutral that Gisela is talking about along the way to help the parties?
Well, absolutely. I think basically any measure that would help the parties have more control over and put in an effort in kind of preventing disputes and solving them as early as possible, and thus also kind of avoiding further cost is helpful. I think construction is known as an industry that tends to be prone to disputes. But then again, for example, especially in the past, I would say 10 or 15 years, in Finland at least, there has been a noticeable leaning towards more cooperational forms of contracting. For example, we've seen a few very successful alliance projects, and the alliance contracting model is fairly even aggressively pushed in the field nowadays. There's also kind of integrated project delivery forms of contracting where I would feel like that is a very natural element to have someone assist you and act as a standing neutral or a dispute board to help the parties in their very cooperational form of reaching the kind of best solution for the project in an overall sense as well. So definitely, I mean, I find that the construction industry would really benefit from having more kind of disputes solved at the onset.
Now, Annette, I'd like to bring you into the conversation. Obviously, we have quite a broad audience today, and some people are from Finland, some people are from various parts of the world, including the Middle East and beyond. And alliancing type contracts might not have been fully penetrating in these areas, but FIDIC has. And so can I help the audience, or can I ask you to help the audience to kind of compare and contrast FIDIC with the Finnish standard forms?
Oh, thank you. I will try to do that. First, I want to agree with all said by Emma and Gisela, and agree fully that as early as possible you should put the mechanisms in place which would assist you in not resorting to disputes and resolving the disagreements early. And I think that the FIDIC suite provides a lot of such mechanisms. I will ask Emma then to comment how is it in the standard terms and conditions in Finland. FIDICs are, to my knowledge, not that much used here. I have myself been using in large energy project, power plant constructions in Finland and abroad, but then it has merely been with international partners. But the FIDIC suite, for those who don't know, it's the 1999 suite was the first rainbow with the yellow book, the red book first, where the employer plans and the contractor constructs, and that included a standing board actually already then. Please, Aisha, correct me if I'm mixing the colors here.
No, in the red.
Yeah, it was the red. Then the yellow and also the silver, which was then the turnkey, included more of an ad hoc dispute board mechanism, which we have actually copied in many contracts, and that has created then the multi-tier. But I think the one other feature of FIDIC compared with the Nordic conditions is that the FIDIC suite includes also the engineer role as a contract administrator. And that is quite alien, I think, to the Nordic system, because the engineer is appointed by the employer, so it could potentially be seen as a bit one-sided. And in a way, it's not part perhaps of the dispute resolution, but it makes several steps in the whole package, which there may be ways to overcome that for Finland or the Nordics, and I could see possibilities to have jointly appointed engineer or jointly appointed a standing neutral who would take the kind of engineer role, because I think that is useful before you resort to the real dispute phase of when you go up the ladder. In the first meeting of this series of DBs in the Nordics, we were discussing the ladder, and you should try to focus on prevention and stay at the negotiation level as far as possible.
And that's kind of what you were saying, Emma, in the alliancing and partnering agreements, right?
Yeah. Now just briefly, in the 2017 suite of the FIDIC, there is standing board as a recommendation in the golden principles for all of the contract models. So that has perhaps removed this, which we may come to in more detail, but the problem with ad hoc boards is that they may turn into mini arbitration, and standing boards obviously have the advantage that the project is known by the board, and hence they can resolve issues more quickly. But Emma, how does, I mean, a FIDIC suite is they are very large contracts and with very detailed provisions. How do you?
Yeah, and we tend to run into FIDIC-based or more tailored forms of contracting, taking some elements from the FIDIC world in industrial projects in the Finnish market. But then if you think about the overall field, the Finnish general conditions for building contracts, the YSC 1998 terms are fairly widely used in kind of general construction, and they really do not lend a hand in terms of establishing a very kind of specific dispute resolution procedure. They basically just lead to general courts, first instance district court, if the parties do not agree. Otherwise, obviously, a lot of the parties tend to lean towards arbitration, and a lot of the parties that do include an arbitration clause, they tend to favor the Finland Chamber of Commerce rules on arbitration, and then obviously can kind of specify further on the procedure. But I think something that's kind of interesting to note, and again, coming back to my comments about these more cooperational forms of contracting becoming more popular in general in the field, is that, for example, in 2007, when the first kind of model contracts based on these YSE general terms for project management contracting, which tends to be seen as a model where the contractor is also very actively involved, and it also requires a lot of cooperation from the side of the employer. In that contract template, which obviously the parties can change and fine tune, but the kind of standard terms set that there should be kind of a level of dispute resolution between the parties' negotiations and the kind of forced solution by way of general courts or arbitration. And the way they worded it was that there could be an amicable resolution sought with the help of a kind of an external mediator who has experience from the Finnish construction field and the legal and contractual elements thereof. So basically it kind of tends to favor an experienced expert in the field kind of acting as a mediator, but it's not something that is obligatory in the sense that that would have to be the step if the parties, for example, don't agree on the person appointed for that role. And again, another example was when the alliance contracting kind of general terms or suggested terms were released. I think it was a little bit over a year ago. There you obviously kind of give a lot of emphasis on the parties themselves and their appointed representatives in the kind of leading group of the alliance solving any disputes that arise. But if there is a dispute that cannot be solved between the parties and in these board discussions, so to say, there is also this kind of outside third-party expert level of basically mediation in those standard terms as well. So those kind of developments already indicate that there is a kind of a small lean towards these types of ADR tools in the market.
Yeah, and I think it's interesting to see globally FIDIC uses a standing board and focuses on resolving issues early and fair and balanced risk allocation. Emma saying that the standard Finnish contracts are also leaning to having some neutral or addressing your issues, identifying them early, addressing them early. But as we know, not everything can be resolved at the project level. So Gisela, from your experience, does having this step or a tiered dispute resolution clause before you get to arbitration, does that help or hurt the efficiency of arbitration?
I think the person who knows the answer to that sort of question generically would be a wizard, because I think we're now at the core of sort of what I think is so super interesting about multi-tiered clauses, and that is that sort of, in my experience, in a good project that has been set up like Emma described, with a fair balance for both parties, and where both parties have the same goal to get to the end of the project happily. I think, well, first of all, the need for a multi-tiered clause, of course, is less obvious. But even though I guess we all know that in every project there are issues along the way, and in such a project, of course, I think a standing board, for instance, gives a huge advantage, because they resolve technical issues along the way and really sort of prevent disputes from escalating and thereby sort of supporting the project and its efficiency. On the other hand, in projects where maybe there isn't such a balanced contract, and or for some reason the parties' interests are not aligned when it comes to bringing the project forward, if basically the project is set to fail, and let's face it, some projects are, there, of course, a multi-tiered clause can end up sort of being very difficult from an efficiency point of view, because what then often happens is that the parties engage in the pre-step, be it then an adjudication or be it the dispute review board setting, with the aim of positioning themselves for sort of the end fight in the arbitration. And in those cases, of course, it's counterproductive for efficiency to have a dispute board or other, tiered dispute resolution mechanism. So I think, to the extent possible, when negotiating the contract, of course, it's good if the parties can take a view to the future on sort of do they sincerely believe that this project can be sort of concluded with the parties still having aligned interests. And if that's the case, then I definitely think that there are efficiency gains with DRBs.
Yeah, I hear there's no magic bullet. Dispute boards can help you if you want to be helped.
Yes.
Is that also your experience, Annette?
Yes, I think there is, as Gisela says, there is a slight risk for misuse, although that should not happen in large-scale projects with defined outcome and where the parties, for example, in long-term contracts, are dependent on each other for very long periods in terms of service and spare parts, etc. So it shouldn't happen, but of course I think I've heard of examples where there was an ad hoc, not a standing board, not a standing board appointed from the beginning, or a board appointed from the beginning. Because let's face it, it's easy when you conclude a contract, you accept that there will be a dispute, you put the proper system in place, and you may even appoint a standing board. Then it's easy to agree on it. Again, if you have the old system with the, I think it was the Silver Book Close project, where you have the ad hoc board, and then there are a multitude of issues which arise. Then you can play with starting up here and there different dispute boards or different adjudicators, and that can potentially mess it up and stall the project for long periods, because then it becomes a nuisance, because actually you would like to go to arbitration directly. So I recognize that risk is, and I think that is also behind when I speak to other company lawyers in Finland. Many say that is just the dispute board is just another level of nuisance and additional cost and etc. But I think it stems perhaps from these kind of cases, or perhaps more kind of on-off, not the large cooperative projects, which I think we more talk about here. And also that the standing boards have not earlier, or standing neutrals, been that much used. I think they are much coming now. For example, I mean the FIDIC 2017 and also ICC 2015, which I have been participating in project using that standing board. That is perhaps cleaning the table, because when you have a standing board appointed from the beginning, it means that you're not playing games so much, because you get bad bill if you start to play procedural or other games, because the same people will then decide on the matter. And then also according to these rules, the decision of the dispute board can be shown to the arbitrators afterwards, unless you have agreed otherwise. So that whole line, I think, is improving, hopefully.
Well, interesting, because maybe I should have asked the question in the sense of, if you have a standing board, does it improve efficiency, or an ad hoc board, does it improve efficiency? And maybe, Emma, we are exactly at the top of the hour now. So we finished half an hour. We're gonna finish. We have another half hour to go. So I'd like to move on to talking about standing versus ad hoc dispute boards, and kind of explaining or helping people around our virtual table seeing the benefit. Is there a benefit? Annette is saying we're moving that way, but is there really a benefit? But before I give you the floor, I would like to invite our audience members to, if they have any questions and if they want to engage, we welcome that. So please type your questions in the chat or in the Q&A, and we can. And we have one question. Thanks, Brian. And it's about, does the panel consider that a standing board should comprise a minimum of 3 members, including a chair or one person in the board, or an ad hoc board of 3, preferable for smaller projects? So I'm gonna, Emma, I'm gonna ask you to comment on standing versus ad hoc, and then take that question.
Sure. Well, I'm very strongly in favor of a standing dispute board if a dispute board is used. I think it has several benefits when comparing it to an ad hoc established board. And I think the best part is that you actually receive the benefit of a kind of well-informed, long-standing engagement of the expert, and kind of the quickness to react comes from the fact that the board is already informed of the project details. It knows the project, gets information from, for example, minutes of meeting and maybe some disputed items that arise during the project. And in that sense also can kind of quickly adjust to any questions directed to it or claim items to be solved. So I think this kind of project knowledge kind of supports the goal of having a quick resolution to the claim items. And in general, I feel like when you know that there is this backbone of an external, be it one expert or several experts, it kind of raises the bar on what type of disputes you direct for them to decide upon in a way, or give their recommendations, because of course the parties would likely want to appear kind of good project as establishing good project principles and kind of having the control to solve the easy problems during the project. So I kind of feel like it encourages cooperative behavior so that as little amount of disputes as possible gets directed to the outside parties. And sometimes I feel like the standing board can even act like a sparring partner, in the sense that nothing really prohibits the parties from also relying on kind of informal information exchange in addition to the formal DRB procedure with the experts. I feel like sometimes the parties are very candid in saying, can I just spar and discuss in general? Of course, there are procedures that can be established for the more formal proceedings of a dispute board, but I feel like it kind of establishes this good working relationship at its best. And in that sense, it can also resolve some problems or help the parties solve them before a dispute even arises. Like you can have a Q&A or maybe some informal recommendations or kind of notes on proceeding in some matters. And I'm actually also of the opinion that the standing dispute board is likely to be more cost effective than the ad hoc, because even though you have to kind of engage them earlier, and of course there will be some costs related to them familiarizing themselves with the projects, I feel like the ad hoc proceedings tend to kind of take on the procedures of mini trial or mini arbitration more easily than this more kind of maybe informal, already established standing board would. So that might also lead to cost efficiency for the standing dispute board.
And is that also your view? Do you share Emma's view, or do you have a different view? We like controversy.
No, that's very much my views and my experience as well. But many contracts don't have standing boards yet, and for the ad hoc, just to comment, the ad hoc, I think it's important. They can work well also, but it's important to focus on the scope of the issue you bring to an ad hoc board. Of course, that the same goes also for adjudication within a standing board, because if you have a limited issue, you want a quick result, for example, that now the contractor has left the site, it doesn't have the right to leave the site, please rule on that, and then you can get from an ad hoc board also a quick decision.
I think that's a valid point, that at best the ad hoc can really be like a tailored solution and a quick one at that. And yeah, I fully agree with that as well. And maybe the one thing that I have to say, I'm kind of trying to create controversy with what I just previously said myself, but the good thing about having an ad hoc board is that usually in that situation, the parties have already acknowledged that maybe they would have benefited from some outside perspective. And it might be that in the best of circumstances, with parties that are really intent on actually solving a problem, the ad hoc can also be a really good tool for that as well. And especially with parties that kind of acknowledge that they don't want to make it a mini arbitration and kind of pile up costs, but also obviously depends on the experts appointed in the ad hoc. I'm aware that I didn't comment on the question regarding one or several experts. Does anyone else want to comment first? I do. I'd
like to invite Gisela to comment first on that, sure. Because I think the and also we have another question of adopting. So when you start looking at 1 or 3 and costs, assuming you support standing boards, maybe you don't, and that's fine too. We can go that way. But we have also another question from Gibril saying, what are your thoughts on adopting a dispute board for a smaller size project or projects of a lower value? So kind of integrate that with the cost issue, and then we'll circle back to Emma.
I think I'm a great fan of standing boards for large projects. And then I think there should be 3 members. That's sort of the model I think works best. There's one word of caution though, maybe, and this is maybe also to bring a little bit of sort of discord into the chant of excitement over standing boards, and that is I have wondered sometimes if there's a risk with a 3-member standing board in a large project, that the opportunity for the board to rule in favor of, or to find in favor of either party is not that great, because if you have a standing board, one could argue that there's a larger risk that the board wants to always, find the middle ground, because otherwise it won't sort of be able to bring the project further. And that, of course, can be, I would assume, pretty frustrating in a situation where you're the party where actually basically sort of you are right.
You want to win.
Exactly, you want to win and you should win, but due to the mechanism or the psychology of the standing boards, you don't. So that's maybe sort of the one word of caution I would bring. Otherwise, I would definitely be in favor of a 3-member standing board for big projects. On the small projects, maybe this could be a good situation to, or a good context to to remind the audience of the SEC Express, which are new rules by the Stockholm Chamber of Commerce, where basically the parties in particularly maybe smaller projects, why not bigger projects too, can get sort of an ad hoc expert, one person to look at their case and, you know, thumbs up, thumbs down, or resolve a question within a very sort of short time period and for a predetermined sum of money. So I think that could be an option in smaller projects.
Yeah, I could comment. I have also with Gisa thought about this when you have a standing and then there comes issues for resolution, and you think, are they going to find the middle ground or so? But I think it depends a bit on how you phrase. They are not, I mean, these disputes are not, if they are not created kind of arbitration-like, but more so that the parties are asking questions, and there can be a multitude of questions, and then the adjudication panel then of the standing board answers these questions. They are, perhaps that is more recommendation like phase, but I have not really seen much problems with this. It's a concept, or it's a way of working also in these disagreement cases where also the engineers and the project understands the outcome of the recommendations and decisions, because that's how they are made. But then I saw there popped up a question, and I actually had also a comment in relation to what Emma said, and giving sounding board, etc. with the panel members. That has to be open, obviously, with all parties, and I think that is important to state, because there are a lot of ethical rules and the dispute board rules, both ICC and FIDIC, which the members would adhere to. So no communication goes only to one party. Everything goes always to everyone, etc. So it's with open cards.
Yeah, that's a good complementing comments, and I basically meant that, for example, when the dispute board is engaged, for example, in site meetings or something like that, that all the parties would obviously be present in these liaisons with the dispute board. Maybe kind of coming back to the question of whether there should be one expert or three, fully agree that in big projects, I think 3 is a good norm. But I think especially to kind of think about smaller projects and cost control, the essential thing is that the expert, he or she, one or several, enjoys the party's trust. And I feel like one person who is kind of well familiar with obviously the legal kind of contractual side of things and can kind of engage in the project is definitely a viable solution for smaller projects. I even have some experience myself of having clients basically on both sides of the table, meaning I would have a conflict if I were to act as counsel for either party, but they've basically kind of very informally or jointly asked for an evaluation, basically a recommendation with a few kind of good justifications for a resolution of a particular theme. And this can also be kind of a dispute board light if you were to think of it that way. So definitely, I think something that I want to stress, and I feel like it's kind of ingrained in the Nordic countries kind of mind, and especially in Finland, you have to respect the parties' kind of autonomy to kind of decide on what type of dispute resolution they want. And even if you don't have a standing board in your contract, even if you don't have a multi-tier dispute resolution clause, I think it's a very valid thing to do for the project parties to kind of be aware we actually have some means of solving this. Let's have an ad hoc board. Let's have it be, for example, one person that we know and trust, and go from there. So the parties' kind of independent control kind of rears its head in those situations, I find.
Well, I think you bring up a really good, Emma, I'm not sure that you had read the Q and or the chat, but
No,
but
no.
John Papworth was saying exactly very much what you were saying, that building that rapport and really helps. And if the sole dispute board member is able to build the rapport on a small project, you can make it cost effective, but it also equally works well with large projects. So you're, I think,
Yeah, I'm just reading it now.
that view is very well shared. And I'd like to kind of circle back to the concept of tailoring tools to the party's will. And I think that's one of the key, the key features of dispute boards is that you can have a dispute review board, or you can have a dispute adjudication board, and they can give informal opinions, and you can set very specific rules and having procedure and adjudicating a dispute. So I'm going to kind of invite each of you to share, have you used and tailored the dispute boards through party will or party autonomy, working with your clients to start out with this tool, but then tailoring it to the specific needs of the project and the specific needs of your clients? And I'd like you also, we had a question about how do you improve ethics, or how do you ensure that, let me just read, so I'm not paraphrasing, from Santiago, and how do you reduce potential of ethical issues and conflicts? So when you're tailoring your dispute boards, so Emma, I'll start with you and then kind of go around our virtual table.
Well, first to touch on the ethical issues and conflicts, I mean, obviously I would want the experts to be appointed to think of it as they would if they were asked to be an arbitrator, and obviously be mindful of any conflicts. And I think Anne already posted on the chat that there's obviously several guidelines on kind of establishing ethical proceedings as well. Would probably be a good idea to at least kind of informally refer to something like that being abided by. But as for tailoring dispute board procedures or dispute resolution clauses in general, yes, there have been several instances where, for example, in PPP projects, alliance contracts, and also in some project management contracts, where I think most of the discussion has revolved around whether or not you should make the kind of mid-step of mediation or an expert recommendation or even a binding decision obligatory. That's always something that is, like I think Gisela said earlier, it's hard to know what type of dispute might arise during the project. So I think there tends to be this hesitancy of kind of committing to an obligatory middle step before arbitration or the general courts. But also there was a time when I was part of a piloting project of the Finnish Association of Civil Engineers that kind of were piloting the use of dispute boards in Finland. I think it was almost like 20 years ago or something. I wasn't even a lawyer back then. I was only just studying, but I was part of coordinating the project and part of a panel in one instance. And in those discussions, basically as the representative of the organizer of the board or the member of the board, we obviously had lengthy discussions with the parties piloting those boards on what their wishes were, how specific terms they want to set for the proceedings, the binding versus non-binding nature of the ruling or recommendation. So those would definitely be some of the aspects that you would touch upon.
Gisela, can I turn it over to you?
Yes, I've seen tailoring, and I think what I think is super interesting, and the tailoring, maybe just as an example, you take the ICC dispute board rules, and then the parties together decide this we want, we don't want that, we strike out this and that. And an interesting reflection, of course, is that that is never done, or I haven't seen it done in arbitration. And to what extent there could actually be sort of an interest in sort of whether here's an opportunity for cross-fertilizing from the dispute board scene into sort of mainstream arbitration, because of course, to a certain extent, there could be a tailoring need also for arbitration rules. And that's, I think, one of the advantages when you think of dispute boards as a mechanism, that there is a tradition of tailoring the proceedings, also on basically starting from the rules.
And that, yeah, I mean, I think it's a valuable tool, and that is customizable to the needs of the parties, and that I know that you've used dispute boards on fairly large projects, and I don't know if you want to share any of your insights into tailoring.
Well, yes, there has been obviously a lot of tailoring, and before the standing board, actually there has been cases where you have started off with ad hoc board procedure because there were only rules about those in the 90s, for example. And in some of these cases, the ad hoc board has not functioned at all, and both parties may have been of the opinion that they don't function. It's just another layer, and agreed to jump directly to arbitration. And then there are cases where too many kind of dispute board procedures have been started before as a precondition to arbitration. But interestingly, there's also been cases when the standing boards came more into play, where the ad hoc rules in the bespoke contract were transferred into a standing board in the middle of the project, because there was a need for having the project, as you know, energy project, at some phase they come into testing modes, they come into commissioning, and a lot of there is an advantage of third-party technical expertise on the site and the like, and it has been interesting to follow it, and very good results. I would say a multitude of tasks have been given to the standing board, everything from agreeing on long-term missions to detailed monitoring, possibly monitoring during demonstration runs, etc. So, but on the ethics and this side, I think, and abiding to the rules, I think it's very important, the role of the chairperson or chairpersons of the standing board and whatever board, if it's three-party board, is very important, because that's usually a lawyer or combined lawyer engineer, and sets really the flavor of the work for and distributes the tasks within the board. Then there can be cases where just one of the members does something, etc. Or then for decisions the whole board convenes. But as you hear, all kind of tasks and rules are applied.
Yes, which is very interesting, because like your last point, Annette, we were saying that you can just convene the whole board, convene one member of the board, depending on the issue at hand. So I think you can tailor it and make it cost effective, even within 1 or 3 or 5 or however, but it's open to tailoring. And I think we have almost 5 minutes left, so I want to expand and then contract, but I want to expand first by saying, well, we can tailor it. We've heard of construction and we've heard of energy sectors. Is it possible to use dispute boards or this concept of a dispute review board or in other sectors? And Gisela, can I ask you to comment on that?
Sure. So I definitely think that any sort of complex project, I think dispute review boards lend themselves best to complex projects with a fairly sort of where there are fairly technical issues, and that's of course why constructions and other projects, infrastructure and that type are sort of the main target. A group of disputes that are of course on the rise and that we see much of, which resemble these very much, are IT transformation projects, which are huge, often very technical, and where there's sort of, they're too big to fail. So there's really the need to find a way forward together. And especially sort of there's this technical element. So that's a group of disputes where I definitely see a potential for dispute boards going forward. Another type of disputes where I have given some thought to sort of whether those could lend themselves to dispute boards are of course shareholder disputes or joint venture disputes. To the extent that sort of, we're not talking about a very technical, well, joint venture is of course a different thing if there's also construction involved or if it's a project dispute. But if we think of a shareholders agreement, in my personal opinion, I think there some kind of sort of facilitative mediation would probably work better than a dispute resolution board or dispute review board, because of the mere fact that sort of, at least in my experience in shareholder disputes, quite often it is sort of, they aren't that technical, but still there's a huge need to get the parties to sort of walk together in the same direction. So maybe I would not, if a client asked me, would I put the dispute review board in a shareholders agreement, I would probably advise against that and go for a facilitative mediation clause instead.
Yeah, I think when there's high emotions, you might want facilitations more than decisions or recommendations, possibly kind of like family law or the like. But we are sadly quickly approaching our final minutes, and I'd like each of you to kind of leave the audience with your thoughts on the Nordics and dispute boards. Or so, Annette, may I invite you to start?
Thank you. I think the recommendation would really be to consider seriously standing boards at the inception. I mean, I'm talking about large scale, but also perhaps smaller ones with one standing neutral engineer or the like, who is appointed already at the inception, because that is the best of preventive contracting and proactive contracting. In my view, it's not just another layer. I think the DRBF statistics tell that the costs of having dispute review boards in place are kind of promilles when you are talking about percentages, when you are having to resort to arbitration. So I think they are cost efficient and, as noted, can be tailored to the needs of the project. I very much agree with Gisela also that not only large scale industrial projects, energy projects, IT projects. I've been in one which badly would have needed a standing neutral. So I think I will conclude with that.
Gisela?
Yeah.
Thanks. Maybe sort of, I think from my side, the most important takeaway is really at the outset when negotiating the project to take a view on sort of how does the balance of interest between the parties, what does it look like, and where does one think that the project will end up, and then take sort of a realistic view on what the sort of array of dispute resolution mechanisms is that one would like to include in the contract, because there's no one size fits all.
Emma?
Well, I think I already emphasized that the parties should kind of take it upon themselves to kind of aim for effective resolution regardless of what has originally been their dispute resolution clause. So to kind of have faith in these new tools as well can definitely vouch for having a standing board. I'm realizing I have several kind of closing thoughts, but maybe to touch on what John also commented in the chat about establishing trust, that if you give the board, be it one member or three, a good chance to familiarize with the project and rely on their expertise, I think it's very likely that a well-reasoned decision, even in situations where you cannot kind of have a mid-ground and you really need to make kind of a strong argument for one recommendation in favor of the other, I think these well-reasoned decisions really help promote kind of positive process and are to the benefit of the project as a whole. So I really feel like the more cooperative contracting you have, the more you should really rely on these external helping hands as well.
Well, thank you. And my final thought has nothing to do with dispute boards per se, but it has to do with this has been incredibly super interesting. And to thank you, each one individually and collectively, for making this such an interesting and robust discussion about dispute avoidance, where we can use dispute boards, where we can't, or where we should, or what we need to think about. And I think this goes a long way in the Nordics to start the conversation. And this is only the start of the conversation. So thank you again, and I look forward to many more interesting exchanges and cross collaboration. And to the audience, thank you for your questions, and thank you for your thoughts. And we wish everybody a good evening, good day, and good night. And we look forward to seeing you on the Danish Roundtable and beyond.
Thank you to everyone who participated.
Thank you. Bye.
Bye. Good night.